even though we anticipate that compliance is a natural consequence of a decision being made by a legitimate, court, or treaty body, or other tribunal. Experience has shown that states don't automatically comply with the decisions without a further push from the litigants, from the mechanism that made the decision. So in many contexts, we have found it necessary to be deliberate in specifically following up with the mechanism that made the decision, with the hope of getting, in many of these decisions, there is a requirement for reporting back within 180 days at both the Commission, the Court, the Children's Committee. So what we have done is to deliberately write to the Commission, for instance, to say, we received this decision 6 months ago, and in terms of the decision, there's a mechanism for reporting back. Can you provide us an update on what the state party has reported so far? Because we want to put the ball in the court of the Commission to update us on whatever it is that the state party has done, so that if you have the information that the state party has actually not done anything yet, then we would take it upon ourselves to follow up with the state party towards getting their feedback on what measures they intend to take in compliance with the the decision that has been taken by either the Commission or other regional human rights mechanism. In other instances, we have utilized what we have called implementation dialogues. The idea of implementation dialogues, as we have done in the past 2.5 years or so, is essentially to organize conversations at the national level, bringing together the litigants, government representatives, national human rights institutions, such as your National Human Rights Commissions, ombudspersons, or other kinds of institutions, civil society actors, broadly so-called, but those that specifically work in the thematic area on which that decision was made, and other international partners, to dialogue about what exactly is the challenges, affecting implementation of the decisions, but also to, raise awareness, the visibility about the decisions, because if we leave implementation only to the people who litigate, oftentimes there is significant impediments to implementation, because there are very few decisions that you would see where the implications are only towards the individuals who litigated. Many of these decisions, especially those that have structural remedies, have national consequence. They require legislative change. They require, policies that need to be put in place. They require budgeting. They require, awareness raising to change practices where you have harmful practices and other kinds of, endemic problems in society. So that it is practically impossible for those individuals or organizations who litigated to be the only individuals or entities that are interested in, the implementation of the decision. I think for us, we appreciate the fact that we litigate because of the victims. We don't litigate simply because we are interested in the public interest of certain legal jurisprudence, which are fine and important, but we litigate because we are entrusted with the stories, the pain, the violations of individuals who want to obtain relief, who want acknowledgement of the violations that they have suffered, and who want systems that are, inclusive and then them to thrive in their societies. So for us, increasingly, we are exploring avenues of using audiovisual tools to be able to tell the stories of these victims, to highlight, the nature of the recommendations that has been made by these mechanisms against the state party, and to tell the consequences of the lack of implementation on these individuals, how it dashes their hope, their expectations, and the need for states to come to the table and to, in good faith, implement these decisions that they accrue to them by account of their freely ratifying these instruments. And I think for us, it is also increasingly important that we continue in those kind of national level conversations that makes these issues part of the broader national social political conversations, because a lot of these decisions have bigger systemic reliefs that are awarded or recommended by these mechanisms beyond the immediate individuals who are directly impacted. So we want to be able to tell the stories of the individuals where they feel comfortable and they are able to share those stories, so that we are able to bring visibility to the issues that are at stake, but also raise awareness about the implementation challenges within the commission itself, and that hopefully we are able to secure the kind of remedies that the victims truly deserve, and that is able to erase or at least mitigate some of the harm that they have suffered, and that increasingly we hope to make these decisions part of the national debates, and that our national constituencies, civil society, national human rights institutions, and the duty bearer, the state and its representatives are very much in sync and are having conversations towards how the more systemic reliefs will be implemented across the board for the benefit of the victims who litigated, but also the many unrepresented victims who are facing similar challenges in communities.